agent, usually they would be contractually engaged by his principal for marketing of his insurance product. So under common law, as well as generally under contractual law, an agent would owe the duty to act in the best interest of the principal in terms of marketing of the product and promotion of the insurer's services. Now, the new amendment ordinance introduces a best interest requirement, as you've just said. What it is, it really says, stipulates that an agent should act at all times in the best interest of the policyholder or potential policyholders concerned, as well as there is another duty to avoid conflicts of interest. Now, putting the rules into context, when an agent is engaged by a principal, usually we'll see that in the terms of the engagement that the particular agent will be obligated to promote solely its principal products, and sometimes its principal's products may or may not be the best products depending on its personal circumstances of the policyholders. Another fact is agents market insurance products in return for a commission. So you could see these two facts alone would create potential conflict of interest as between the interest of the agents, the interest of the principal, as well as the interest of the policyholders. Now, to avoid this, we recommend disclosure would be one of the key elements in discharging the duty. For example, if when at the point of sale, the insurance agents should disclose any potential conflicts of interest to the policyholders or potential policyholders concerned so that he or she may make an informed decision when determining which products to buy and from whom. So remuneration and the fact that the agent only markets its principal's products. IIA will in due course issue further guidance on this particular subject matter, and in particular how agents can deal with situations where a potential conflict of interest arises. I would think, from what I have seen so far from the draft of various certain working groups preparing transitioning to the new regime, that there are various things an agent can do. For example, at a point of sale, an agent should take reasonable steps to understand the financial standing and the resources of his or her potential clients, and as well as their insurance needs. And against those findings, he should try to recommend the products he thinks most suitable to that particular client. I mean, obviously, he would have to disclose, because of his contractual arrangement with the principal, he can only promote products which are offered by his or her principal and not anybody else's. And another, it is quite important that an agent should ensure it has the very thorough knowledge of products offered by his principal, so that he would be able to advise and properly his customers as to which products would suit him or her the most. Going back to the disclosure issue, it is quite important that all relevant disclosure, the pros and cons of any particular product, any potential conflict of interest that he sees himself in, should be disclosed to the policyholders, and the policyholders should be given time to digest all this information so as to make an informed decision before purchases.